Alors je sais, vous allez me dire...
Now, you may say we're 1 hour ahead of schedule. Fair enough, but today's Friday, and Friday, I think we can be a little bit more flexible with a schedule and take some time to take things easy on a planet which is in peril, maybe because of the pandemics, but we have the feeling that's behind us. But that's not necessarily the case. We may be faced with the prospect of other pandemics. And I don't know whether you caught the disease, and maybe you didn't. Maybe you're the only people who never did catch this. Jacqueline, Sandrine, and your team. So the planet is threatened, maybe even worse than that. Climate change, well, are we experiencing this every day? It all depends where we live. But here in The Hague, we're beginning to experience it. Last summer, it was a little bit like Cannes over in Scheveningen. So do you have any doubts whatsoever as to the existence of climate change? I think that's a thing of the past. Yesterday, I believe that we heard a very inspiring speech saying, well, the planet will recover. Personally, the planet isn't my subject. My subject is life. Will life, in fact, survive, as it were? Mars survived as a planet, but what about life on Mars? So life, the ecosystem, Gaia, as the dreamers may say, is in danger. And can international law help us? Should international law have a rethink as to its very foundations, faced with this terrifying prospect? I'm terrified for my children, for my grandchildren, maybe less so for myself, but I am terrified. So do you believe that international law, which I believe in so much, can reassure me by changing, undergoing complete overhaul? And can you help us? Sandrine, Jacqueline, over to you.
Merci beaucoup. Je voudrais commencer par...
Thank you very much. Well, first of all, I would like to thank the entire team of the Academy. I'm extremely happy to be here today. The Academy counts a great deal for me. Its project, its very existence. It's a place for an intellectual adventure, but also for friendship, and I'm delighted to be involved in this anniversary. So it's true, as Jean-Marc reminded us, very few global issues are more urgent and serious today than climate change. In fact, it has become part of the international political agenda, well, over and beyond the annual conferences of parties on climate, and has led to major legal developments. Nonetheless, this is still insufficient given the challenges we face. Hence, how is climate change, in fact, calling into question the existing mechanisms and rules of international law, and how can international law be adjusted or adapted or reset in order to rise to these challenges and prevent irreversible damages for humanity and the planet? This whole issue of climate change is very topical because you know that 3 international courts have been called on to deliver advisory opinions on this subject. This was at the very heart of the work of the Centre last summer. I'm afraid we cannot present you with the book yet. It hasn't been published yet, but no doubt it will come out at the end of the summer. So the center focused on the way climate change is challenging international law. And here, this is the outline of our presentation. First of all, we want to quickly take stock of the situation, and then secondly, we'll have a look in greater detail at the various solutions which have guided our work and the conclusions that we reached. So here you have the first part, our first point, the idea that we're talking about an existential threat for mankind and the planet. I'm not going to dwell on this subject because Marianne Lemoine will dwell on that in greater detail and tell you about scientific knowledge. But what is worth stressing during this introduction is that climate change, in fact, is forecasting an era of uncertainty, which will be marked by large-scale, largely irreversible and unforeseeable changes once the tipping points have in fact been reached one after another. Science has been established, but our reactions, be they collective or individual, are not sufficient. The greenhouse gas emissions are still increasing at global level, although scientific contributions are very contrasted. Adaptation to climate change is also insufficient, although of course the very resistance and resilience of our societies today and in the future depend on that. And what the IPCC has underscored is that seeing that the threat is global, international cooperation is an essential catalyst for any reaction. In other words, it's an absolute prerequisite. International cooperation dates back quite far because already in 1988, the UN Scientific Council considered that climate change is a common concern for mankind. Climate is one of the essential conditions for life on Earth, as the General Assembly pointed out, and also said that necessary measures had to be adopted in order to deal with climate change. The international climate regime, as we know it today, is the outcome of a long, lengthy negotiation process which started in 1988 with the setting up of an expert body, the Intergovernmental Group on Climate Change. In 1992, the first convention was drawn up with the framework convention of the UN Framework Convention on Climate Change. And then 5 years later, 1997, the Kyoto Protocol laid down goals to bring down greenhouse emissions, but only for the industrialized countries. And very quickly, that proved to be largely insufficient. The scale of the challenge, in fact, requires the involvement of all states, both in the north and in the south, in order to combat climate change. And that emerged quite clearly following the failure or the semi-failure of the Copenhagen conference. We had to wait until December 1995 for an agreement to be reached in Paris, the 21st COP in Paris, and the ensuing treaty, the Paris Agreement, entered into force 1 year later. And today there are 195 parties. This international regime, which was developed step by step, has no doubt allowed for progress, but it is noteworthy that it still remains largely insufficient. Besides, the whole issue of climate change is a cross-cutting issue, and therefore it must also be taken on board well beyond the international climate regime. And here, we would like to show you a diagram, a figure which we prepared together. This was done by the Center, and it highlights the climatization of international law. Climate change has been discussed so many times since the beginning of the colloquium, and this in fact attests to the progressive climatization of international law. And this diagram is meant to show you how climate change has led, in fact, to a number of shocks. leading to the climatization of international law, which is based on the principles of international environmental law, and is now influencing other regimes outside the climate regime. Indeed, even rules which do not primarily have to do with climate change, but which are relevant and fundamental in order to find efficient solutions, such as the rules governing trade and investment, to mention just the most important one. And seeing the international climate governance, in fact, involves a whole range of players and needs to be applied at different levels. The effects can be seen at horizontal levels, on other spheres of international law, and vertically as well, at different levels in terms of governance, and especially in terms of the various players involved in climate governance and the responses which are found at international level. For example, we can see the way international courts are currently being asked to deal with cases involving climate change or provide advisory opinions. And many references are made to this. Another example is national requirements in terms of accountability for firms, which draw inspiration from international standards with a view to mobilizing private funds to combat climate change. And now I would like to address my second part to try to give you some insights into the amount of work which has been carried out, looking at this from different standpoints. Now, the first series of ideas is the whole idea of regulating these issues given current uncertainties. And of course, we have looked at prevention obligations ranging from the precautionary principle to the Chamber of the International Tribunal on the Law of the Sea. And all of these proposals are extremely interesting. We also looked at the relationship between experts and decision makers, diplomats. Climate change, in fact, has given rise to a number of controversies, and science has played a fundamental role by influencing the international climate regime. It's henceforth been set up, it needs to be implemented, but we still require an input from science, and that is precisely what Marianne Lemoine is going to do in a couple of minutes. And we have also given thought to a paradox, namely the need to comply with the constraints of state sovereignty, whilst in fact dealing with ambitious rules. The principle of state consent, of course, remains central today, but international law, in fact, has undergone a number of changes, and the ways the states have become involved have varied, whereas the formalization stage and the adoption of rules and the sources of law have developed because of soft law dependence. And this change is very clear in the area of climate change, with a need for international cooperation on the one hand and resistance from states on the other, have necessarily meant that we have carried out experiments in terms of the sources of law. And I would say that here, maybe even more than with any other treaties, the Paris Accord shows us that states, in fact, commit to evolving the form and the substance of the agreement has enabled the states to reach a difficult consensus as regards the form. The Paris Agreement is the outcome of a subtle combination between hard law and soft law, as it were, meaning that the provisions had differentiated legal content. The Paris Agreement also highlights a subtle combination of the bottom-up approach with certain contributions established by the states and top-down, ensuring an international transparency framework. And despite the non-prescriptive approach, the Paris Agreement, in fact, is bringing more pressure to bear on states, including and especially at national level. With the mobilization of civil society, it's becoming more and more difficult to simply make do with specific contributions at national level, which put together don't necessarily lead to a drastic decrease of greenhouse gases, and in fact have not allowed us to head in the direction of what is stipulated in the Paris Agreement, Article 2. The Paris Agreement has made a decisive contribution in increasing the number of cases and have let the international law actors to play a part. And although the results aren't yet entirely satisfactory, this renewed commitment on the part of states have led to renewed forms of control, which in the long run could in fact make for greater effectiveness. And this is what we hope. As regards the Paris Agreement, it's also relevant to look at all international rules as a proper system with elements which are interconnected, and hence the environmental principles and case law play a key role where different rules play a different part coming from different regimes and foster a dynamic interpretation of international law, which can mean that its consistency can be improved and in turn its effectiveness. Customary and conventional rules don't work in isolation, but on the contrary are interconnected, and this means that they can sometimes enjoy cross-fertilization. And courts very often call on other international sources such as customary rules, soft law instruments in order to interpret and apply convention rules. And the arbitration on the South China Seas have shown us the interest of a particular interpretation of conventional rules and customary rules. Climate change trials give us another example, and we have a combination of sources of domestic law and international law, and the applicants in that respect are in fact very inventive and are asking judges to combine sources and norms in a creative way. Finally, an interpretation of a norm in the light of another means that if these can mean a lot more than if the norms were applied in isolation. We saw this with the Uganda case in Holland, where the Dutch judge applied a combination of domestic and international norms, written and unwritten rules, which in fact fall both under climate law considerations and human rights law. So, in a system which is constantly evolving, a state's consent could and should, and this is a question we ask, be seen as consent to a process, and more specifically, consent which aims for standard setting evolution whose outcome is unknown when this is proposed. And climate change, in fact, means that we need to adopt a new approach, a climatized approach when it comes to state consent. So thank you very much for your attention, and I shall hand over to my colleague Jacqueline Peel for the rest of the presentation.
Secretary General, Excellencies, colleagues, and friends. Sandrine spoke of friendship within the centres, and I think that one of the great benefits for me of directing the centre last year was the friendship not only with Sandrine, who I hadn't met in person up until that point, or I think only briefly previously, and the friendship with our centre participants. So thank you for that experience. I bring greetings from Australia and our Indo-Pacific region. I was reflecting when we were listening to the panel before on epidemics that just before the COVID pandemic, Australia saw fires so severe that they could be seen from space. And indeed, the skies turned red and ash fell from the sky. So for our part of the world, we really stand on the front lines of climate change. It is not a future problem. It is our present reality. It's my job now to take up the story of our centre's deliberations on this topic. We weren't sure, being the final session, whether we would have 45 minutes or an hour and a half, but we are very adaptable and used to uncertainty in the scientific area of climate change. One of the key challenges that climate change poses for international law is the mismatch that exists between a truly cross-cutting issue and, in fact, an international law and governance system that is very fragmented. As Sandrine spoke of, international law has concentrated its efforts to address climate change in the international climate change regime, the UNFCCC and the Paris Agreement. But the issue is one that spills outside of this regime and is emerging as a focus of other areas of international law. And in the Centre's deliberations, a lot of our focus was on these developments in other international law regimes, whether peace and security, international investment law, looking at our colleague Carlo sitting in the front row there, trade and human rights. This raises the question of how to address these spillovers, these boundary crossing effects, whether that's through enhanced coordination, integration of regimes. In fact, last night at the dinner, Sandrine was explaining to me her theory that what we might need to do with different rules across different international law regimes in solving the climate problem is a kind of blender approach. Put everything in the blender, shake it up and see what international laws are delivered. I will hereforth refer to this as the blender theory of international law. Or beyond that, perhaps institutional reform of global governance. Just as climate change is an issue that cuts horizontally across different areas of international law, it obviously also vertically cuts across different levels of government and governance and a different constellation of actors. So climate change is paradigmatically a multi-level governance issue with relevant rules at the domestic level, at the regional level, at the transnational and global levels. The example given here is the supranational role, for example, played by the European Union, where the European Commission plays a major part in formulating climate policy. And we're seeing already discussion of things like potential trade measures taken by the EU to create a level climate playing field in terms of actions to address greenhouse gas emissions, or even related directives like the one that was discussed yesterday, the Due Diligence Directive, which targets corporate social responsibility for many problems, but also potentially extending to climate change. Indeed, as we heard several times yesterday, there are many actors involved in this space, including domestic courts, who are playing a major cross-cutting role as boundary travellers whose decisions may help to link and connect the parts. And you may not follow the field of climate litigation very closely, but it's a very active one. We have now more than 2,000 decisions globally from national courts dealing with climate issues. Also, as we discussed yesterday, there are some actors, such as multinational corporations in particular, that sit in the interstitial spaces, the in-between spaces of multi-level governance systems. And regulation of those actors, it has to be done by proxy, either by regulation through states imposing due diligence obligations, but there are also potential transnational mechanisms emerging in human rights and through market mechanisms. This raises the question of whether we are sufficiently recognising, empowering and incorporating the participation of all actors, that will be essential to address the climate problem, especially those particularly impacted by climate change. I think this is very relevant when we look at the International Court of Justice advisory opinion, and we heard discussion yesterday about participation in those kinds of proceedings. Where or how might we hear the voices of small island communities, of civil society, and of youth in a proceeding of that kind? I think this brings us very naturally to the issue of justice, which sits at the heart of the global climate conversation. The issue of climate justice is obviously a global need. We're all going to be affected by climate change. But it's also an issue that's felt more acutely by some communities in different parts of the world than others. In fact, climate change justice largely maps onto the north-south, developing country divide in international law. And we know that those who experience the greatest impacts of climate change are also those who have made the least contribution to the problem. International law certainly has principles that seek to address those resulting inequities. The principle of CBDR-RRC, if you're not an international environmental lawyer, that may be inexplicable, common but differentiated responsibilities and respective capabilities. It's a principle about saying something about the differing contributions and responsibilities of the current generation between different parts of the current generation. We also have principles that address the inequities that exist across different generations when it comes to addressing a problem like climate change. Intergenerational equity is a principle that calls for consideration of the rights and interests of future generations, those that will most bear the impacts of climate change. But do these principles meet the calls for climate justice, like those that are powerfully voiced by leaders such as Prime Minister Mia Mottley from Barbados, if you've heard her speak at recent COPs, or the Pacific Youth who spearheaded the campaign for the advisory opinion request? It's a question that's unresolved, but playing out in litigation right now, both domestically and at the international level. Finally, we considered in the centre the challenge of effectiveness, by which we essentially meant whether the tools we have in our international legal toolbox are up to the job. The climate treaty regime has been very innovative in devising a range of new tools, some of which are up there on the screen, but they're largely procedural in nature. And some, like the global stocktake, which is essentially looking across all countries' contributions to climate change, their policies, and seeing if they add up. That tool is being used for the first time, or the discussions of it are concluding only at the end of this year at the UNFCCC meeting. So we're largely in untested territory. Could rules beyond the climate change regime help supplement the climate effort? This again was a live question for our participants. Could we look to, for example, the enforcement mechanisms of international investment law or of trade law to make contributions and help enforce the provisions of other climate treaties, including the Paris Agreement? How might state responsibility rules play a role in delivering either damages for harm suffered or even potentially reparations for past wrongs? And if this can't be delivered through international courts, what then is the role potentially of national courts to achieve this? Essentially, the questions that we had before us seem to present two paths. First, working with the tools we have, This is enhancing them to make them more fit for purpose. We called this acclimating international law to climate change. The second approach might be regarded as more radical, designing new tools and governance approaches, or even turning the current anthropocentric perspectives on their head. Scientists will tell us that currently we are in a new geological era of the Anthropocene. That is an era in which humans have become the main shapers of our own environment. We are the driving force shaping the environment we experience. Do we then need to move from a territory-based, state-led international law system to a more holistic system, as some have proposed, an Earth system law that would match the boundaries of law with the boundaries of the planet? In conclusion, this is some of the conclusions that we draw in the manuscript and the book forthcoming. We see the depth and extent of the transformative impact that climate change as an existential problem is exerting on international law. And we've described this as producing a climatization. We've heard a lot about humanisation, dehumanisation, perhaps also climatization. But in meeting the existential challenges of climate change, we also find that international law is very, very often not up to the task, requiring new proposals, different interpretations and perspectives, and recognising that since political will has been lacking, these proposals won't always emanate from states. We think, however, that climate change is a challenge that all international lawyers can embrace and contribute to. So we issue a call to action to lead in that respect. Let me leave you with a quote from a Marshall Islands poet, writer and youth leader, Kathy Jetnell-Kilchner. She says, "I ask world leaders to take us all along on your ride. We won't slow you down. We'll help you win the most important race of all, the race to save humanity." Thank you very much. And I now hand the floor to Marion.
Thank you very much.
Your Excellencies, Professors, dear colleagues, ladies and gentlemen, it is both a great pleasure and a great honour to be able to share the conclusions of my work on the occasion of the centenary of the Hague Academy of International Law. Allow me to thank the Academy and also, of course, my research supervisors, Sandrine Maljean-Dubois and Jackie Peel. On behalf of the whole French and English-speaking team, thank you to both for their invaluable support, their generosity. Thank you for the impetus that you gave to our work in a spirit of collective intelligence. Thanks to this extraordinary experience at the Centre d'études, we have had the most wonderful time conducting this project. Thank you. My research focused on international law, which is challenged by scientific developments. I studied more specifically the role of the IPCC when it comes to the structuring and the operation of international climate law. Sandrine and Jackie already said there was a great degree of uncertainty, also growing uncertainty because of the expansion of the problem. The problem is growing ever worse, and scientists say that they are less and less in a position to really gauge the impact of these accelerated changes. The aim of my research was to understand how, in 30 years of existence, the IPCC, this unprecedented platform of expertise, how, together with international climate law, they interacted with very fruitful and original results. We've already heard something about that. It's also part of part 2. But also, of course, it encountered serious limitations in terms of effectiveness, implementing existing rules. And because of all of this, I wondered whether we needed to revisit the science-law nexus under the circumstances. That will be, in fact, the subject of the last part of my presentation. Methodologically speaking, I'd like to point out straight away that I used an epistemological approach, which was aimed at understanding how scientific knowledge is structured, developed, how it interacts with legal decision-making processes. It was a kind of reflexive approach on the creation and evolution of international law. It was made possible thanks to the support of other social science disciplines. The reading of IPCC reports, of course, invites you to consult these sources, and I would invite you to do that in order to weigh up the strengths but also the weaknesses of our international law in their context. By way of an introduction, I should perhaps say a few words about the IPCC. It's quite a unique model when it comes to the transmission of contemporary knowledge. It was created in 1988 under the aegis of the World Meteorological Organization and UNEP after several decades of climate research, in fact. In its 30 years of existence, the IPCC has carried out 6 cycles of assessment on scientific knowledge on climate change, causes, impacts. It has produced 6 multi-annual reports and numerous special reports. The IPCC operates on the basis of some main principles and 3 working groups. You can see them here up on the PowerPoint slide. And it also works by consensus. It's important to know that. It's not just a scientific forum. It's also a diplomatic forum. Indeed, when it comes to the plenary assembly, and by that I'm referring to the 195 member states of the IPCC, I mean, they have essential roles to play, electing the Bureau, approving the IPCC budget, and when it comes to scientific work, they decide on the summary of forthcoming reports, they appoint authors of reports, and that's on the basis of lists that are drawn up by the member states themselves, and they also approve a 30-page document known as the Summary for Policy Makers, which we're sharing with you today. They approve it line by line, and also they endorse a multi-year report, thousands of pages long, in fact. So really, I would say that the decision-making process at IPCC level is eminently political, in fact. Now, let me give you some insights into the state of scientific knowledge right now. We broached it already, and I think we can concur in saying that it's very alarming. The reports demonstrate, with a growing degree of certainty, that climate change is on an unprecedented scale and that it is moving forward ever faster. I refer you here to the most recent IPCC report. Look at the curve, the red line in particular. That's the trajectory, bearing in mind implementation of not only international law but also existing law as applied in practice. And you can see that the level of warming is more than 1.5 degrees on the surface of the Earth as of 2030, in other words, tomorrow already, and then average global warming of more than 40%. And for France, that would mean plus 5%, in fact, in actual fact, if you take that as your scenario and if you take as your point of departure the beginning of this century. So that's why it's so important to move towards the blue line or the green line underneath. Those are, in fact, the lines that shouldn't be exceeded in order not to exceed the line of dangerousness that you'll find in international agreements, in particular the Paris Agreement, which speaks about 2%, deploying all necessary efforts, and indeed 1.5%, or degree. So this would mean, actually, that we'd need to cut net global carbon emissions by 45% by 2030, compared to 2010 levels. On an individual scale, sorry, because after all, it's important for us to bear in mind what we can do individually. That's part of the order of magnitude, if you like. So on an individual scale, we're talking about going from an average of 10 tons equivalent carbon emission per year, 10 to 2 tons only of tons carbon emission equivalents in the near future. And that's, of course, not it taking into account all other sources of emissions, and by that I mean housing, transport, heating, food, etc. So just to give you an idea of what we need to do as a society, how much we need to change in order to meet the targets that were set in the Paris Agreement. Now, let us move on to the next point. A systematic study of interactions between international law and the expertise of the IPCC, on the other hand, allows us to reveal a number of things. First of all, there is a growing and very strong reciprocal influence between the IPCC and the international legal systems. That's very interesting if you look at the treaties and agreements that we already have. And it's actually more and more strengthened. There's more and more cooperation, if you like, between science or expertise and the law. And in a way, this runs counter to two hypotheses commonly held. First of all, the autonomy of science, allegedly, kind of neutrality. And in fact, if you look at the procedures of the IPCC, they're supposed to be policy relevant but not policy prescriptive according to the text. But you'll find that actually a lot of the decisions taken are intrinsically, social, economic, political, all of the above. And there's a kind of increasing proceduralization of knowledge assessment cycles. And this has to do a lot with the values that are originally presented as purely scientific. So it becomes more and more a turn to the procedural. Secondly, second hypothesis, the linearity of the expert assessment model, which assumes that scientists will provide ex-ante information to inform governments before decisions are taken. Well, actually, what you'll find in practice is a lot of circularity between these different bodies. It's a kind of ongoing dialogue, a hybridization of standard-setting processes in both bodies. That's the actual situation on the ground. Now, there are standards, and they are co-produced, and that's led to a number of major advances, which I think I should highlight. First of all, IPCC reports have played a driving role in the development of the law. Each new report has led to a treaty or ambitious COP decisions. There's also a normative hybridization of treaties, and thanks to that, we have a global epistemic community on a universal scale with a common vision of climate change, and it's interpreted as a global pollution problem, a problem caused by excessive greenhouse gas emissions, and a problem that should be curbed in accordance with a calendar that is predetermined and agreed on an international scale. And thanks to that common representation of the problem, international law has been able to set legal targets when it comes to mitigating GHGs, for instance, Kyoto Protocol -5%, and also a warming ceiling of 1.5 degrees carbon neutrality according to the Paris Agreement. So all of those are targets set by that mechanism. Furthermore, the scientific benchmark enables a procedural evaluation of the efforts made both individually and collectively, and maybe we'll talk about the global state of play a little bit later on. Also inclusive international standards. Sandrine talked about that earlier on. I would say that, there's a balance to be struck here, and it's been possible thanks to a continuous process of legitimation, and science has certainly played a very important part in that. So the Paris Agreement has had a turn to the procedural. You can see it in the agreement, and it means that science has almost hegemonic position when it comes to determining the way forward. I think that's an important point to bear in mind too. Now, having said that, this global representation of the problem is also often used as a pretext by some states. They use it to justify delays in legal texts or weaknesses in legal texts, avoid targeting activities that really cause climate change, and by that I mean fossil fuel, or indeed certain sectors. They want to avoid pointing the finger at that. And so in the end, you end up with a kind of representation that is quite abstract or disconnected from human agency, from the anthropo side of it. But again, there is a relationship between the law and IPCC reports, and there's a sort of parallel language used on one side and the other. More and more turn to the technical, soft law as well. And I think that really shows that there are some lacunae here, even in the area of international law. But it's also a question of legibility for international law, and of course bearing in mind the repercussions that it will have at different levels in terms of climate change. Also, hybridization between science and law, which has been conducive to convergent climate governance. The IPCC reports are in fact a reference point, undeniably so, reference point for a number of stakeholders, both public and private, and that happens at different levels. You can see this, for instance, in the discussions taking place right now. Allow me now to come to my conclusion. I'd like to speak about the way forward, this nexus between science and the law. What can we do going forward? So reform has been suggested on both sides. Is it possible for us to perhaps rethink the question of effectiveness, which I know is of great interest to international legal experts, particularly those that have an interest in the environment? I mean, there are proposals for reform within the IPCC to try to take into account the political dimension of debates increasingly, and also to look at expertise with a view to finding solutions, and maybe not just look at medium-term or long-term perspectives. Also, maybe using that expertise to deploy them in the interest of operational goals, so that stakeholders can really take ownership of the orders of magnitude we're talking about and map out some socio-economic trajectories that are reasonable. I think that this nexus, this connection between expertise and law, I really think that it does provide us with some opportunities. I think we could actually look at things more sectorally, and that includes, by the way, UN negotiations on climate change. And I think it's also an opportunity for us to do more collective learning, to focus on solutions, and to integrate, if you like, common sense into more territorialized solutions. And that brings us back to the need to look towards IL not in silos, not separately, but rather in terms of its articulations and links with other areas. Finally, I would argue that the consideration of the irreversible nature of climate change, I mean the tipping points, and Sandrine talked about that a moment ago. You know, there's a sort of tipping point, a dangerousness level beyond which we don't know what's going to happen. This really is an immense challenge for international law. And in a way, it raises questions about its ability to promote a precautionary approach and to also extend its driving force to all the other scales that need to be involved to deal with this emergency. Thank you very much for your kind attention.
Thank you, Marion. Thank you, Sandrine and Jackie. Dear Excellencies, dear professors and friends. My research topic in last year's center led to a chapter that is now entitled Through the Looking Glass, Climate Change and the Law of State Responsibility. And on the basis of this, I would like to briefly make the argument in the coming minutes that the law of state responsibility, despite being surprisingly often overlooked, is actually quite well suited in order to achieve accountability for failures in climate change mitigation. And I think that that is due to, in particular, three reasons, which is, first of all, the law of state responsibility is a regime of secondary rules, and as such it is particularly malleable and facilitates finding primary mitigation obligations. Second, the law of state responsibility poses requirements for establishing a claim that are particularly flexible and as such accommodating the complexities that characterize climate change. And thirdly, it provides for quite impactful legal consequences and avenues of enforcement. But before I go into the details of these advantages, I would like to briefly outline the background, which is, of course, the obvious need for mitigation, for effective mitigation of climate change. And, sorry, how do I? Okay, thank you. Apologies for that. So, of course, there is a need for effective mitigation of climate change, but in light of the hesitancy that we can still observe by states, that is paired by a need for accountability for climate change mitigation failures. And that poses quite a challenge to international law for several reasons, of which most of us will be quite aware. So there is, for example, the highly complex and indirect chain of causality between a state's greenhouse gas emissions, then the aggravation of global climate change, and in another step, then concrete and local harms resulting from climate change. And despite the indirect chain of causality, the establishment of causality is quite often required in order to attain accountability. In addition, we find several limitations in the international legal frameworks that are most regularly invoked in order to establish accountability. So, what was already mentioned is the predominantly procedural nature of the international climate change regime. We are all aware that, unfortunately, there's no substantive mitigation obligation in the Paris Agreement. And yesterday, it was already mentioned that there is an increasing resort to human rights law to argue mitigation obligations. Nevertheless, those mitigation obligations based in human rights law are still rather domestic and inward looking, which we can see in that they are mostly brought forward by citizens against their home states. Now, all of this is not to deny the success and importance of these avenues, but it is rather to highlight that they are somewhat incomplete. And it is in particular to highlight the lack of an effective mechanism for interstate accountability. And that is where I think that the law of state responsibility can unfold its potential. And as I already hinted at in the beginning, I think that that is the case, especially thanks to its nature as a secondary regime of international law, which provides only procedural secondary rules that reference substantive primary rules that are external to the law of state responsibility. And that leads me to the first and most general advantage of the law of state responsibility, which is its malleable nature and the necessary search for a primary mitigation obligation. Because despite a primary obligation being located outside of the law of state responsibility, it is the substantive heart of any claim of state responsibility. And in light of this, I think that if we take the law of state responsibility seriously as a perspective, it can function as something like a looking glass for the landscape of potential mitigation obligations that are the looking glass book. That is to say that the law of state responsibility facilitates an external perspective on primary obligations and facilitates the identification of obligations that otherwise often go unrecognized. And I think that this is the case because it forces us to focus not only on the substance of obligations as we usually do, but also on the legal relationship between states that is created by obligations. And in addition to that, because the law of state responsibility is secondary, it can immediately free ride on primary mitigation obligations that are newly emerging. And I think that this capacity is particularly important in the case of climate change mitigation, where hopefully primary mitigation obligations are subject to rather sudden developments and evolutions. Now, in my chapter, I try to illustrate this rather abstract argument by giving the example of the interstate mitigation obligation that we can derive from human rights law as an obligation erga omnes partes if we look through the perspective of the law of state responsibility. But for the sake of time, I'm afraid that the details of this argument I will have to leave to another conversation. And instead, I would like to focus on a second general advantage of the law of state responsibility, which is that once we have found a primary mitigation obligation, the requirements that are put forward by this legal regime in order to establish state responsibility are particularly flexible. And in order to appreciate the importance of this advantage, we can remember the challenge that I mentioned in the beginning, which is the indirect chain of causality that characterizes climate change and the harms resulting from it. Now, under the law of state responsibility, in order to establish that there is a wrongful act, basically the only thing that we need is a breach of obligation. So in our case, that means that under a mitigation obligation, a wrongful act would exist as soon as the state enacts insufficient mitigation measures. And a claimant would not need to establish causality between those individual mitigation failures and then harmful consequences resulting from climate change. As a third advantage, once we have established that there is a wrongful act, the law of state responsibility provides for particularly impactful legal consequences. As a legal consequences, there is, of course, first of all, the obligation to cease the wrongful act and comply with the original obligation going forward. But in addition to that, there is an obligation to provide reparation for any injury that is caused by the breach. And here I would like to highlight that among the different options for reparation, a preference is given for restitution. And I believe that this preference for restitution can incentivize the wrongdoer to take additional restorative mitigation efforts in the future, or potentially even resort to technologies of carbon removal. And thus, the obligation to provide restitution as a consequence of state responsibility can play an important role in the global effort for an effective mitigation of climate change. Now, we all know that if we have a claim of state responsibility established and we have these impactful legal consequences, that is all well and nice, but much still depends on the enforcement of such a claim. And there, of course, the jurisdiction for an enforcement depends primarily on the primary obligation. But we have heard yesterday already that enforcement of such claims can sometimes take a lot of time if they are enforced in judicial proceedings. And there I think it's important to consider another advantage of the law of state responsibility, which is that in addition it provides the option of countermeasures to be taken by injured states as a more proactive form of enforcement. And thereby it is not fully dependent on normal proceedings. And I think that especially in light of the urgency of climate change, this is quite a crucial advantage. So, in order to conclude, I hope that these advantages could highlight that it is the generalist and secondary character of the law of state responsibility that renders it particularly useful for meeting the challenges of accountability for climate change mitigation failures. And on a broader level, that there is an importance of a novel appreciation of the potential that general international law holds in the law of climate change. So to sum it all up in one sentence, I believe that the law of state responsibility can illustrate the potential that we can find in embracing the climatization of international law. Thank you very much.
Secrétaire général, on a le temps pour...
Mr. Secretary General, do we still have time for a few questions? I'm Jean-Marc Touvenin, Secretary General of the Academy, and I have a rather practical question. What is the following internet site worth? Climate change tracker. I believe that when we look at their work, it seems as if they have the ability of showing quite easily, even for people who are lay people, the efforts which have been made by certain states, and therefore as well what has not been done by certain states with different zones, orange, red, etc. Is it worth anything? Is it interesting? And if so, this way of naming and shaming, does it have any impact whatsoever? Carlo De Stefano.
To both Jackie and Sandrine, or either, as you wish. You inserted this reference to global reset in the title of the session today. So I ask you, if possible, to further elaborate on this concept and maybe to substantiate how the urgency in the fight against climate change is different today compared to 2015 when the Paris Agreement was concluded. Thank you very much.
Thank you very much. It's more of a procedural question to Ms. Lemoine. I just wondered the relationship between the IPCC and the Secretariat of the UN FCCC and how then the IPCC is represented in the conferences of state parties. Thank you.
Thank you. Eric de Baats, former treasurer of the Academy. I have a question which relates to the session of this morning, which was on international inspections. And it relates to the lecture of Mr. Reitz. You state international law is malleable, which offers an opportunity. Would you say that international law with a view to enhancing the environment and mitigating climate change is fine as a basis, and that we only need to make sure it's turned into practice and that we sort of need more inspection on rules that are already fine? Or does actually the regime still needs further development, for instance, in terms of sectoral regimes like were mentioned? Obviously, it's much different if you're active in the energy sector or in certain resources like textiles or refrigeration and air conditioning with impacts on HCFCs and such.
Laurence Poisson-Chazot.
Laurence Poisson-Chazot, thank you very much for your presentations. I have a question for Marion Lemoine. You compared science and law. You spoke about the IPCC as a scientific institution, and you spoke about the legal regime which has been established. But when we have a close look at the reports of the IPCC, in fact, this disseminates an ethical, social, scientific discourse. And how can we draw a distinction between the enrichment of science and the type of society which is defended by the IPCC? Is it possible to distinguish between these? And if it were possible, what is the type of society, the model of society which is being advocated by the IPCC? Thank you very much for all these questions. Now, as regards the first question regarding the Climate Action Tracker, it's an NGO which provides information and it's updated on a regular basis. I believe that it's a valid site. I use it a great deal, and the advantage of this is that the information is updated regularly, whereas reports which are produced, for example, under the climate regime, needless to say, come out annually or every 6 months, and therefore, in the meantime, it's sometimes quite difficult to obtain information. And they, for their part, really try to update the information regularly and aggregate all national contributions to see what trajectory they place us on, and they assess each national contribution. So it's quite a useful tool. But note that this year there will be a stock-taking exercise, which in fact will complement this kind of tool. Because in actual fact, we have a great deal of information about all these subjects. It's not the information which is lacking. So it is indeed a valid site, and it's very useful.
Which was about the title and the question mark, global reset question mark. And you asked to further elaborate on whether that's the direction in which we need to head, particularly with an increased sense of urgency now as opposed to Paris Agreement in 2015. I'm going to take that from two different perspectives. One is the science perspective, because I was fortunate to participate as a lead author in the Intergovernmental Panel on Climate Change in the Working Group 3, which was the report on mitigation. And the main message of that report was actually that we have all the tools that we need. We just need the political will to deploy them. So in that context, we're not talking about radical new evolutions of technology to deal with the problem. We have most of the solutions at hand. In the legal context, I think we face a different challenge, though, in that we don't have necessarily all of the right tools or the most perfectly adapted tools to respond to the challenge. The question, though, is whether we have the time to engage in a wholesale global reset. I think one of the other IPCC authors in releasing most recently the 6th assessment report, which paints a very dire picture really of the global temperature increases and the short remaining time for action. The response was that we need everything, everywhere, all at once. And I think that this approach also applies for us in international law. There are contributions that can be made across the spectrum, both in adapting existing regimes and in that bigger picture, blue sky thinking, but I think everything needs to occur all at the same time.
Merci beaucoup.
Thank you very much for these questions. And as regards the procedural dimension and the link between the IPCC and the bodies of the climate change regime. In fact, work is carried out in collaboration between both the IPCC and the UN bodies. That is already underway, and expert groups, in fact, receive the messages from the IPCC before handing them over to the legal spheres. But what I see in actual fact is that this is not always necessarily the case. During the first decades, this worked well, and the scientific discourse was in fact transmitted to the decision-making bodies. But now there are other ways of referring to the IPCC reports over and beyond the internal bodies under the regime. And as regards the Secretariat, Jacqueline, in fact, was involved personally, so I'll hand over to her.
There is a formal observer role that the IPCC plays in the UNFCCC negotiations. But more recently, what we have seen is the Conference of the Parties calling for the IPCC to make specific interventions to the COP process. So we've seen, particularly at last year's COP, a call for the IPCC to report on the impacts of climate change. I think this will also be very relevant for the forthcoming COP, where there's a lot of consideration of the potential mitigation options. So there is, as Marianne was discussing in her presentation, an increasingly close relationship between the treaty-making or implementation body and the scientific body of the IPCC.
Yes, thank you very much for the question with regard to international law as it is, and if it is a sufficient basis, if we just put it to a good use or if we still need change. And I think both is the case. So I tried to give the example in my presentation that there are quite some powerful tools in international law as it currently is if we put them to a good use. But I think that there is still a need for change. I mean, I mentioned primary obligations, and even if we may find some in the current state of international law, the more the merrier and the stronger the better, of course, in a case like climate change. So there is, I think, still quite some need for change and improvement. And Jackie mentioned political will, and I think both options depend highly on political will. But I think that may pose a little bit less of a hurdle maybe in putting to use the international law that we already have as compared to making further changes, which is something to consider there. Thanks.
Je reprends la parole pour répondre à la question de Laurence Boisson de Chazourne sur l'opposition.
I'll come back to the question that was asked. Initially, I made a distinction between science, expertise, and the legal decision-making process in the United Nations. That's what happens in the guidelines of the IPCC on the one hand, and on the specificity of law on the other hand. However, through nexus and couples and co-production phenomena, what I wanted to show is how linked they are, interlinked they are within IPCC and within international law. And therefore, this separation or opposition is no longer true in action because practice has gone well beyond that. Regarding the gradual growth of the various disciplines within IPCC since 1990 or 1988, more precisely, social and human sciences are increasingly important, and Jackie is part of Working Group 3. And this is quite interesting for internationalists because the analysis of international law and its effects is being analyzed by other scientists, both legal experts, but also scientists and social and other fields. And they see it with a different lens, through a different lens. Regarding the society model proposed by IPCC in its report, IPCC is criticized for being very Western, very anthropocentric, and for not opening up enough to other knowledge production models or representation of the climate and nature. And this is the problem we have mentioned yesterday on several times. IPCC, by summarizing all the anthropological knowledge, can highlight the importance of the living on this planet and the knowledge of indigenous communities by highlighting the importance of the community or the collective as opposed to the individual positioning. But I think that the question remains open on this particular issue.
Sandrine has given me the final word if there are no other questions. And I think the idea was to finish a little earlier on a Friday afternoon. I just want to end with a reflection. Sandrine and I were having a conversation with Philippe Sands when he was here yesterday, and he was recounting a story of going to the Grand Canyon and looking down into the valley and seeing the area where a river had carved through stone over millennia. And he said it struck him that those planetary processes are going to continue. Climate change will not materially affect those, but it will materially affect humanity unless we take urgent action to address the problem. I don't want to end on that note, though, that very pessimistic note. I'd rather end on a note of hope. And I think what this conference shows is that the Hague Academy and international lawyers more generally have the wherewithal to come up with solutions in the time that is required. International law can be creative, can be innovative, can be inspirational, and that, together with all of the young people who are here in the room and contributing to the Academy's activities, gives me hope. Thank you very much for listening for this final panel.